Hello, my name is Crilley. I am a lawyer and a mediator with Crilley Law Offices and Crilley Mediation Services. Many times participants will ask us should they prepare for mediation, and our answer is absolutely yes. So today, the purpose of my video is to give you some suggestions and some hints and tips on how to prepare for mediation. So let's get started. First, I want to talk with you about selecting a mediator. Many times that decision will be taken completely out of your hands because for some jurisdictions, the mediators are appointed by a court order. You will receive a court order, and in that court order, there will be a mediator designated as your mediator. Sometimes that mediator is called the default mediator or the roster mediator, and the name and number for you to contact that person that decision has already been made for you by the court. Many other times it will be your lawyer working in conjunction with the other lawyer, and they will select the mediator. In the event that you have the opportunity to select your own mediator, you may want to look in the phone book in the yellow pages, on the internet for mediators in your area. You may have state organizations of mediators that will list mediators in your area. Once you get the names of some mediators, if you're doing that selection, you might want to check to see if they have a website to get some information about that mediator, or you may want to ask friends or family if they've ever had the opportunity to use a mediator. But as I've indicated to you, you selecting a mediator generally isn't something that you will need to worry about because that decision is usually made either by the court system or by your own lawyer. A mediator is a neutral. It's a neutral professional who will guide your mediation process. Your mediator is not going to make the decisions for your mediation. The mediator is not going to tell you what to do or give you legal advice. Your lawyer will give you the legal advice that you need. Your mediator will guide you through the process. The idea of a mediation process is for you and the other side to have the opportunity to say what you're thinking should happen, to provide information, to say how you're feeling, to talk about what you need. And then the two of you will work on problem solving and work towards resolution. This is called self-determination. So the idea is the mediator guides you through a process of self-determination. The second thing I would like to speak with you about today is the scheduling of that mediation. Once you know who your mediator is going to be, your lawyer may take the process and may go ahead and schedule the mediation for you, and then will tell you that the mediation has been scheduled and when it is scheduled. Other times your lawyer will provide the name and the phone number of the person that you are to contact in regards to scheduling of the mediation. Regardless of whether your lawyer has scheduled the mediation or whether you schedule it, you will still need to have contact with that mediator's office, and generally that is called the screening process. Now, either your mediator or someone in your mediator's office will initiate that screening process with you when you call in. The idea behind the screening process is for the mediator to gather information about you, information about your case, a little bit of information about the other side, and then to ask some questions in regards to domestic violence. Part of that screening is a domestic violence screening. It is up to the mediator to make a decision in cases of domestic violence whether the mediation or the participants are even appropriate for mediation. So, what kind of information should you have readily at hand when you make that call to your mediator's office? Basic information about the case number, if there are any court hearings coming up, your lawyer's name, your lawyer's address, and email if you have it. If you have information about the other side, their address, their email, their phone number, their lawyer's name, that's most helpful to your mediator. You will know a lot of the other information that you'll be asked to give, such as your address, your phone number, and then questions will proceed about the case and what's going on in the case. Having that information available will shorten the time that you will be on the phone with your mediator's office. Do know that some mediator's offices will then also follow up with a written questionnaire that they will ask you to fill in and provide back to them that goes through even more information than you've been asked. Please be prompt in giving that information to the mediator's office. Please be thorough in providing the information and honest. That helps the mediator determine which process is the best process for your mediation. Once you have done that initial screening with the mediator's office, most mediator's offices will tell you that they're going to contact you back with potential times for that mediation. Again, I would suggest that you try to get back immediately with the mediator's office when they contact you with potential times. If you are not timely getting back, then those times end up getting used by other mediations or pass, and then the mediation does not get scheduled in a prompt way. So anytime your mediator makes contact with you, please respond promptly back to your mediator. The third thing I would like to visit with you is that basic preparation before you go to your session of mediation. It is most helpful if you will schedule an appointment with your attorney before you go to mediation. Your attorney can help you develop the agenda for the mediation. It's just a basic question you need to ask your attorney. What should I talk about at mediation? Your attorney then can help you know the most important things to perhaps the least important things, or the most pressing things, the most timely things that should be on that agenda for you when you go to that mediation. Some attorneys, in fact, will send the agenda to the mediator ahead of time. Please don't be alarmed if the attorney doesn't follow every point of your agenda or your agenda at all. The attorney is using that to develop an overall process that is beneficial to all of the participants. The other thing that it would be important to ask your attorney prior to mediation is, what's my best case scenario? What's my worst case scenario? Well, what do you think the court would do if we don't resolve it and we have to go to court? This helps you know the boundaries by which you are willing to negotiate and problem solve within the mediation. And the last thing that would be important to talk to your attorney about is, what documents should you bring to mediation? Your attorney will have those documents readily available at the meeting in the file and can make copies. Sometimes the attorneys will then go ahead and forward those to the mediator for you, so the mediator has them ahead of time in developing the process. And sometimes your attorney will make copies of those documents so that you can take them to mediation. Well, let's next talk about what documents should you bring. A good rule of thumb is to bring any documents that help the discussion about the things you want to talk about. So for instance, if you want to talk about child support, it is important that you bring child support calculations to aid in that discussion. If you are discussing the division of property or assets or 401ks or investment assets, then it's important to bring along documents that help that discussion. Bring along the 401k statement. Bring along your tax returns. Bring along your last investment statement. Any of those types of documents that you can bring along help that discussion. In many jurisdictions, you are required to fill in an affidavit of financial status. It is a document that runs through all the things that you own, all of the debts, and all of your monthly expenses. That again can aid in the discussions of child support, property division, and those types of things. Pictures, diagrams, charts, anything that would again help you to talk about the things you want to talk about. Many times folks will choose to bring along pictures of their children. They think if they have that available, readily available there to be seen, it helps focus them, it helps them stay on track to discuss the best interests of their children. The last item I want to speak with you about is whether there have been any settlement documents that have been going back and forth between the two attorneys. Those documents are sometimes in letter format, sometimes they're in parenting plans. They're called stipulations or stipulations of agreement or settlement. talk with your attorney about whether your attorney thinks you should bring those documents to mediation. Sometimes when those documents are at mediation, they're jumping off points for the discussion. Some people will choose to go through the documents, seeing where they agree and disagree. So what we're doing is we're having a chance to use the work that your attorney has already done for you. Talk to your attorney about whether your attorney wants you to bring those documents or forward those documents to the mediator ahead of the mediation session. We are frequently asked, who should be at mediation? Well, clearly the parties to the mediation should be at mediation. And in some jurisdictions, the attorneys are always at the mediations. Some jurisdictions, the attorneys are sometimes at the mediations. So basically, the idea is that the participants and or the attorneys are there. Because remember, the idea is having a process guided by the mediator that allows self-determination. Sometimes there are other folks that come to the mediations, and I want to talk to you about that. The first and basic rule in regards to anybody coming to mediation, even if it's your attorney, alert your mediator ahead of time. There is nothing that can derail the beginning of the mediation more quickly than having an unexpected person, not a participant, arrive at the mediation and thinking they're participating in the mediation. We are asked whether children should be allowed to attend the mediations. And for most mediators, the answer will be no. The idea is it is not an appropriate environment for children to participate in. The exception to that perhaps would be an older child who has become part of the decision making and part of the discussion because the discussion impacts the child and because you, the participants, have already allowed that child to be part of that discussion. It may be appropriate for that child to be there, but make sure you notify your mediator ahead of time so that both parties agree that the child can be there. More likely than the child participating would be the child's attorney or the child's guardian ad litem, if that is in fact the case. So remember that screening we talked about a minute ago? If you know that your child has an attorney or your child has a guardian ad litem, alert the mediator at the time of the screening process so that the mediator can make sure that that child's attorney or guardian ad litem has an opportunity to participate in the mediation process if appropriate. Sometimes folks will want to bring support persons, new spouses, boyfriends or girlfriends to the mediation. Generally, you should know that those persons will not be allowed in the mediation session and will be asked to wait in a conference room or wait out in the lobby. So you should be aware that may happen ahead of time, and certainly contact your mediator ahead of time if that is your plan. It requires both persons agreeing that those persons can sit in a mediation session for they to be part of the session, and generally that does not occur. Sometimes we forget that there are basic questions about preparation, and one question we get is, what should we wear to mediation? Wear something to mediation that you feel comfortable in. Most people will wear clothes between casual to business casual. But again, the key is you need to be comfortable at mediation. Wear something that you are comfortable in. Your mediator is going to try to set up an environment that is conducive to settlement. And the mediators want to do whatever they can do to make the situation as less stressful for you as possible. I tell my own mediation participants, this isn't a hostage situation, so let me know if there's anything that you need that I can do to make this a better environment for you. Therefore, don't be afraid to tell your mediators if you're too hot or too cold. If you have a hearing problem or an eyesight problem that you know may impact the mediation, make sure you let your mediator know ahead of time so they can plan for that. During the mediation, if you need a drink of water, if you need to take a break, if you're feeling overwhelmed, if you need to go to the restroom, anything like that, make sure you tell your mediator, because your mediators want to make the environment as best as they possibly can for both of you throughout that mediation process. Well, thank you for taking the time of listening of these hints and tips in regards to preparing for mediation. As you find out who will be doing your mediations, check to see if your mediator has a website. Many mediators do these days. You may find frequently asked questions on that website. Browse through those, and that may provide you even more information that you would need for the mediation. Because the goal is to have a good process mediation and to help you feel as less stressed as possible. Thank you.